Hey, Chad, how you doing? You guys wanted that before, so hey, I got to give you what you want. Hope you guys are doing well. Hope you guys are doing well. Yes. Well, yes, everybody's getting denied. Everybody got denied today, so that's the fun part about it. Hope you guys had fun. So, welcome everybody. My name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area, and today we're talking about a bunch of you were wanting to know information about this. There is an update in the saga, the lawsuit between Fuddbusters, Matt LaRose here, also Ivan and the rest of the gang, and Cody Wilson and DEFCAD. So why is this? Come on, focus. There we go. All right. So you guys wanted an update on it. There are some updates. Some of it's a little humorous, but overall, not a lot has changed. Not a lot has changed. But we will address those things. So this isn't going to be a super, super long stream. But like I said, we'll talk about it. We'll talk about it, and we'll get to it here. So the first thing that we will address here, she had running defense like the Army defense and got denied. Well, Ashley says, hello, chat. Today's my wedding anniversary. Well, congratulations. Happy anniversary. All right, so what actually happened here? Oh, hold on, Luke. Yeah, we're going to get to this. I was trying to read your comments there. All right. So here we go. Some deny you get from being your 10 days of being... Hold on, chat. 1 second here. What the heck are you talking about? Moving stuff around here. Blood saying, what does the FUD mean? Okay, real quick, we'll answer this. So the FUD is like Elmer Fudd. And the thing is with basically, well, here's a good example of it. FUDs are basically like casual gun owners, and if you would go to a gun range, you would encounter a FUD. A FUD might be the type of person where you're sitting there shooting. He'll sit there and, he's a casual gun owner, but he owns his only guns for hunting. And if he'd come up to you with an AR-15 and be like, what do you need all them bullets for? And just really generally somebody who isn't about the Second Amendment, but just likes to go hunt and do their own little thing. And they treat other gun owners with scorn and contempt. And there's entire memes about them. And we'll bring up some of these memes real quick because this is actually a pretty good example of stuff. So, let me see here. This would be a great example of a FUD meme here. This is the type of person who a FUD is. Like, they would call the ATF and, they'd be like, well, you're shooting rounds less than 10 seconds apart. You're not doing, just basically they're old timers in the gun industry and in the gun world. And they're known as Elmer Fuds because all they are is about hunting, and they would wear, they'll wear their NRA hats, and they're really just a joke. They're really just a joke. They're typically very much like the most prominent of, NRA supporters, yet the NRA doesn't. Yeah, and here, here's a good example of another thing. Like this is a stereotypical FUD in real life you'd see. Larry, he owns a Mini 14 with 10 round mags, because he doesn't carry. Nobody needs the assault rifles or 30 round clips. He talks about and they're just ridiculous people. They keep a rusted shotgun with slugs for his home defense, and they just generally look down on things, and they call Glocks Tupperware because they're plastic. This is just a good example of what FUDs are. This is a pretty good example of it. They're just they're not even foamers of firearms. Oh no, they're even worse. Vodka saying, I don't get it. The gun range is usually the nicest people. Well, you've had, I will say you are very fortunate. You've never run into a FUD before. But there are a lot of them out there. I've run into them before. I've run into them at gun stores. They do exist. It's not a uncommon thing. They are a real thing there. And it's not only that's not only and they're just the people who they think that, they're willing to, they support assault, they support gun bans, they don't think anybody's coming after their stuff. And they're just generally kind of toxic people overall, but they are a real thing. They are a real thing. And I think Tim Walz is probably the best example of it. If you wanted to see what a real like a FUD is, this is another good example of a FUD. Where he's like, I'm a veteran and a gun owner, but I'm also a dad, and I know gun safety isn't about my rights. It's about keeping kids safe. This is a good example of a FUD in real life. This is a good example of a real life FUD. They're all about doing these things. Yeah, so they call themselves gun owners but support banning everything pretty much. Yes, it's just like the ham radio guys that snitched to the FCC, and for many of them, they are one and the same. The ham radio douchebags are FUDs generally. So, Vodka says a gay guy isn't the greatest shot. Everyone's super friendly and helpful, and I'm glad they are. You are very fortunate that you live in such a very nice area where everybody there has been helpful. But you will run into FUDs at some point in your life. You won't realize it yet. But yes, the sad hams are really close to the FUDs and can, in disgust. Vodka blood, yeah, it says to teach your kids gun safety. Yeah, well, but once again, this is how the FUDs operate. They're the Karens of the gun world. It's not just the gun range, but of the gun world. Yes, they are ridiculous. Yeah, they're part of the common sense gun control crowd. So that's who the FUDs are. Anyway, we're gonna move on. We are gonna move on. I hope that answers the question because yeah, they are a real thing. Yes. Maybe it's just Massachusetts where the gun owners are actual owners. I'm surprised you haven't run into them. They're going to be FUDs, and there's FUDs everywhere. Yes, but if you're at a range, they would get mad if you're rapid firing like more than a round a second or 5 seconds, whatever the rules are. It really is something out there. And Angela says, I know you did that on purpose. Well, of course I did. You have to suffer. You have to suffer. So there we go. There we go, chat. Now, moving on from that, we do have some updates. If you guys remember, we first covered Matt's complaint. We also covered Cody's counterclaims and answer. Okay. Well, Matt filed an amended complaint, and I double-checked with him because I reread through it. And all this is, it's 57 pages, so it's a big one like before. A lot of things that Cody does is Cody has made a lot of statements in the meantime where he has basically kind of pierced his own corporate veil by referring to the company as his company and his employees. So there really aren't a whole lot of changes to this. There are also further actions of copyright infringement that Cody is engaged in, but it doesn't change what is already in here. So overall, they just added more causes of action. You can amend your complaint to do that. So that is not an issue here. And if you guys want to, you guys can check out some of the other stuff that's been done and how they've operated and how they're going after Cody for all this stuff. So that's kind of the thing for Matt. It's not really a big change for what happened with Matt and the Fuddbusters team. Now, if you guys yes, Cody is getting felted here. So now it does get interesting because Cody did file his answer and complaint. Okay. His answer and counterclaims. And we went through this already. And this is the one where he talks about all the defendants. He talks about Matt. He talks about Ivan. Talks about Zona. He talks about Johnny. He talks about the catalog and MAF Corporation. He goes through all of this. All right. So he goes through all the different things that exist here. They talk about the subject matter jurisdiction, the venue, the facts. We guys remember we went through all of this. We went through all of this. It is very, very funny. These are absolutely insane demands and claims that they've made. Remember, they're going to the RICO claim, chat. And what do we always know? RICO is never the answer because it's never RICO. It's never RICO. Not in a million years is it ever RICO. And getting through all his other counterclaims. And then we get to his answer. But then ultimately we get to this part here on page 106. So what are they doing here? On page 106, they make a motion. And because remember, this is under they're filing their case as violations of the Lanham Act, but they're also asking for attorney's fees. Okay? So they are asking for reasonable attorney's fees here. Ooh, that's why did the color not stay? They're asking for reasonable attorney's fees. All right. And then what happens from there? Well, they're asking, they'd say their title award reasonable attorney's fees. They say it a lot. They're talking about reasonable attorney's fees. They want their reasonable attorney's fees. They want the cost of the action. They want, other than attorney's fees, but including attorney's fees. They want every cost made recoverable. Okay? So they're asking for everything. They're asking for everything. They're asking for all of their civil actions as well. They're asking for everything, okay? That right there, but then they also get more prayer for relief. They want an award of reasonable attorney's fees for the entire action. Okay. So that's something we need to think about here real quick. And guys, I apologize. It's not going to be a super, super long thing here, but it is the update. There's an award reasonable attorney's fees for the entire action. Okay. So Matt has filed an amended action. Well, Cody wanted to file an amended complaint as well. And they both agreed to it. And Matt agreed to it as well. Cody asked for it. Matt said, I'm sure that's fine. So the court has come in and said, okay, well, it's up to the judge's decision now because you can only file an amended complaint after it's been served and answered to with leave of court. Remember, so it's been answered to now. So the order came before consideration without oral argument, and they wanted a joint motion for extension of time and to amend the complaint. All right. Well, you go down, and what do you find? What do you find so very quickly? Thereon it is ordered in part, the motion, therefore is ordered the motion is granted in part and denied in part. So, the court notes that it doesn't comply with the local rules because it does not include a memorandum of legal authority to support. Now, this is critical, chat. Your local rules are critical. There might be rules of civil procedure. Then for the 11th Circuit, there's rules. And then for the Middle District of Florida, there are rules. Remember, guys, and then from there, each judge can have his own rules. You need to make sure you follow all the rules. If you don't follow all the rules, you're going to have a bad day. So, so here's the issue. So to the extent that Matt gets it without opposition, the request is granted and Matt shall file a proposed amended complaint. So the defendants shall respond to the amended complaint set forth as procedure. They don't get any more time. And Matt gets to respond to any counterclaims asserted by Cody. And that's done in the counter complaint. And that was signed on December 11th. What does that mean for Cody? Well, Cody doesn't get to do a new one. So Cody's stuck. He's got his. The court's not allowing him to go again. From here, it gets very interesting, chat. Now we're moving on to this. Cody ended up, and we never covered this at the time, and this is just because it wasn't as important to cover, and because Matt's time is very valuable. Cody had filed a motion to dismiss under Rule 12B of the Rules of Civil Procedure. So he filed this motion to dismiss, and we're going to go through this real quick. There's a summary argument and everything. We're going to blow through this real quick. So Matt pleads 7 counts of copyright infringement. And then he's got the Lanham Act, and then he's got the non-copyright claims. And they say all should fail, many should fail immediately. So they argue that they first moved to dismiss under Rule 12b-6. Remember, that is a failure to state a claim upon which relief can be granted. We hear that all the time. So it's a failure to state a claim upon which relief could be granted. It does not target the complaints 1 through 4 claims, but they're arguing those are invalid for a litany of reasons that separate motions will address. Right now, they're just arguing the state level claims. And they're arguing that the second is the defendant, Dioscuri LLC. Remember, that's kind of that's the weird one that Cody has, one of the weird LLCs he has. They're asking that it be dismissed for lack of personal jurisdiction. And remember, you have to have personal jurisdiction over a party. The court has to have subject matter jurisdiction, meaning it has to be able to hear the kind of case. It's got to be the proper thing for that court to deal with. But then you need personal jurisdiction. That party needs to avail itself to the actions or the protections of your state so you can establish minimal contacts. Or if you come in and defend yourself, well, now you're in. So at this point, they're looking to challenge for lack of personal jurisdiction. And they would argue the challenge does not pertain to the other defendants who opt not to dispute personal jurisdiction in light of the counterclaims. And they argue that, they are not going to, the details of the works in question are not important. And they're going to get to this later as part of their argument. Now, they go through this and they keep arguing that Matt's argument is that Cody sells and offers for sale and advertises USB flash drives that contain the same sort of works found on DEFCAD through its e-commerce website, Ghost Guns. And they argue what the complaint does not contain are any well-pleaded facts alleging that Matt is a direct competitor of Defense Distributed or, in this same market. And they say, on the contrary, the complaint discusses, to the extent it discusses any commercial activity, it's limited to a single paragraph. Now, part of their argument is, they're saying, Matt's not admitting that there's a commercial competition issue here. Well, that doesn't matter. Remember, guys, Matt is doing things however he wants to. Cody does not get to claim, because we're not competing. Now, it's very much, they say, we're going slow here. They say, beyond a single paragraph, nowhere does Matt allege he is involved in any form of competition with Cody. They say, very much to the contrary. Matt goes so far as to angrily deny involvement in that area. He angrily denies it. I don't really recall him being very angry about it, but okay. And they say in a competing entity called the catalog. On that point, Matt could not be clearer. Plaintiff Matthew Lossier does not own or direct the catalog. So Matt goes even further in establishing that he is not a competitor to Cody. Specifically, he asserts a standalone cause of action for false designation of origin under the Lanham Act. In this cause of action, Matt claims Cody made statements falsely stating or implying that he was associated with a competitor. They say, as said below, this is why Matt's Lanham Act claim fails, because it does not plausibly allege any violation of the narrow commercial competitive interest with the Lanham Act protects. And they go on to state that Matt fails to allege facts sufficiently to plead a viable claim under Florida's right of publicity law. And they say because these types of laws would otherwise broadly and unlawfully interfere with the First Amendment, the statute has been narrowly construed by the Florida Supreme Court to only apply where the defendant uses the plaintiff's name or image in a commercial advertisement. They say they're arguing it's like putting Tiger Woods' name on the golf ball. And they're playing Tiger Woods endorses that brand of ball. Although I'm going to argue, if you argue where it came from as part of the description of it, that's no different. And they say nothing in the complaint claims that they have used his name or likeness in a commercial advertisement. And they say finally the last claim of unauthorized infringement of Matt's unregistered, but otherwise copyrighted works. Well, no, a bunch of them are registered. In other words, Matt seems to understand his infringement claims require that the works be registered with the Copyright Office, and they have been. Thus, because some of the works were not registered, Matt takes a position that he still may recover for their infringement using other equitable legal theories as a state law unjust enrichment claim. Now, this is where this is actually true. So, the Copyright Act, the Lanham Act, expressly preempts any and all state or equitable theories, including unjust enrichment. And we talked about unjust enrichment before, chat. It's the idea like if I wrote you a check to buy your car, and then you never gave me the car, or you let me drive the car for a bit, then you're like, I need it back, and then you never give it back to me, nor do you ever give me the money. Well, I don't own the car, you've never given me the car, and you still have the money. So, yes, did you commit theft? Yeah, that's a separate matter. But if you have the money and the swag, well, that's unjustly enriched you. And they argue that you can't use state or equitable legal theories to attempt to create exclusive rights in any work that falls within the scope of works protected by the Lanham Act. And they said for these reasons, Matt's claims fail and should be dismissed without a leave to amend. Well, the court granted that, so he loses. Now, remember, they're moving to dismiss the other claims here. And they say count 5, the Lanham Act claims are invalid. And they say count 5 is the attempt to plead the Lanham Act claim for the false designation of origin in unfair competition. And they state a claim upon which relief can't be granted because they fit, and it says relief can be, and he should say can't. A little typo there, but once again, no big deal. People, typos are typos. Because they fail to satisfy the connectivity requirements of Section 1114. And because they fail to allege the requisite kind of confusion. So they go on to further state that, count 5 both fails to plead the marks in question were used in commerce and also fail to plead that the marks in question were used in connection with the sale, offering, sale, distribution, or advertising of any goods. And they're saying the competitor-critic distinction is key. And they say that there is no Lanham Act violation for merely fact-checking statements made online or punishing any and all forms of critical commentary. Well, are you arguing that, is Cody now trying to argue that he was offering commentary? Because that's not what he was doing. He was selling stuff. There was no critiquing. There was no commentary. It doesn't work. Now, they go through all of this, and they point out that there are connectivity issues here. They say that the Lanham Act does not create a federal cause of action for defamation. Now, they're arguing this is a defamation case, which I don't believe so. Now, they are making an argument here that the Lanham Act is designed to protect consumers who have formed particular associations with a trademark and a copyright, a mark. Buying from a competing product would allow the mark holder to distinguish his product from his rivals. And the Supreme Court has made it clear that trademark infringement law prevents only unauthorized access of a trademark in connection with a commercial transaction in which the mark is being used to confuse consumers. Well, it's being used to confuse consumers. Cody's trying to hold it out as his own. And he's charging people. So, yeah, that is an issue here. And they argue trademarks only give the right to prohibit use so far as it is protect the owner's goodwill against the sale of another's product as his. Which is what he's doing. He says, I don't want Cody selling things and using my name. And Cody doesn't have the right to sell them anyway because they're mine. So I don't understand why he's making this argument, think he's going to win with this. But remember, it's Gingras, so he's a little bit weird. Let me see if you guys have any questions here. I want to get too far. I said swag. That makes me a Fed. Yeah, that's the thing. Matt is not an anger type of guy. This is a Matt type. Matt's just a Matt guy. No, Cat. This is Cat. Hold on here. As we go back up here, this is the defendant's motion to dismiss. So this is that 12B6 stuff they were doing. It's defendant's motion to dismiss. So it's the defendant's. So hope that makes sense here. Now, I would say, where were we? Where are we? Anyways, we're getting through all this here. The bigger issue here at this point is getting to the end, and we're gonna get through the rest of this real quick. We're just gonna chug along here. So they go through all this. They make more and more arguments about the rules, about it's whether or not there's wrongfully affecting commerce, and I think that this is gonna fail. Because they argue this is going to fail because there's a lack of confusion. You have to show the defendant's use caused consumer confusion. Yeah, who actually owns this? Who's the one who did it? I think they're going to lose on this. I think they're going to lose. I think Cody's going to lose on this. This is not going to help him here. This is not going to help. This is pretty much going to fall apart. Either way, the funniest part here is the Rule 12b2, and that's for a lack of personal jurisdiction. Cody's trying to get out of this, and they want to dismiss the entire case for lack of personal jurisdiction. And they say, though the plaintiff bears the burden of proof pleading these facts, the complaint fails to do so. And as a matter of law in this complaint, the dismissal is warranted. And they say general personal jurisdiction only exists if the defendant's forum contacts are so continuous and systematic that it can said to be at home there. Yes. And they say under this test, the state of Florida, and by extension, this court lacks general jurisdiction because Dioscuri is only home in Texas. And they point out that, yes, Dioscuri is incorporated in Texas. Now, they argue that just because he was advertising, selling, and delivering works in the infringing state, and they say that's nowhere close to the continuous and systemic threshold required by Bauman and its progeny. And they're saying there's also no specific jurisdiction that exists. And remember, we talked about this, chat. It constitutes your availment of the forum itself. And they say the complaint alleges paragraphs 61 and 60 supposedly meet the test. Yet there are extremely scant contacts, essentially just the maintenance from Texas of a website that reaches Florida like every other place on earth. And they're making the argument the internet goes everywhere, so that's not fair. It's kind of like in the Smash JT lawsuit we talked about last night. Well, his website and YouTube, yes, they reach New York, but that shouldn't be enough. And they say that just because they committed tortious acts in Florida, including, but not limited to, the distribution of copyrighted works, which could be and were accessed by Floridians, including Matt. Now, they're pointing out that this fails because the complaint never alleges that Dioscuri actually did anything in Florida. They said there are allegations about the company broadcasting a website. Those allegations are not about a relationship with Florida. And they say the same is true to the allegations about corporate forum abuse. To the extent any of these matters constitute minimum contacts, they're contacts only with Texas, not Florida. And they say that this violates, and they say that the attempt to get personal jurisdiction violates 2 key rules upheld by the Supreme Court in Walden. They say, first, Walden makes it clear that jurisdiction over Cody and his shell company is impossible here by reaffirming a longstanding rule about whose contacts matter. The contacts count towards purposeful availment only if they are created by the defendant himself. not if they are created by the plaintiffs or third parties. So the minimal business contacts and the interactions, you can't go out and get them to do it and induce them, and then you can say, well, I've got it. They're arguing that's not true, and that's not fair. And they're saying the jurisdictional theory violates this rule because the only Florida connections are attributable to third parties, the Floridians who chose to interact with Dioscuri in Texas. And the fact they chose to reach out to a Texas company is not enough. They make another argument, though, and that minimum contacts analysis looks to the defendant's contacts with the forum state itself, not the defendant's contacts with people who reside there. Remember, chat, this is availing yourself to the protections and laws of that state. And they say, the ultimate question is whether the defendant's actions connect him to the forum. Now, they argue that at bottom, the complaint's case for jurisdiction over Dioscuri rests on little more than the business maintenance of the website and passively offering products to the entire world. And they say that doesn't suffice. And they say merely posting a passive website does not constitute the solicitation of business in Florida. And that's fair enough. That should make sense. And they say going further, and likewise because electronic communication from out-of-state offices into Florida do not establish conducting business in Florida. Yeah. And they say everything in the complaint really focuses happened away from Florida, lacking any of the purposeful direction to this forum that precedent requires. And they say for these reasons, the complaint's feedings fail to establish the LLC's relationship with Florida. Should be dismissed. Well, we do learn there is a learning to this, and so they did make an order here. So the court issued an order earlier this week, and this is something you guys were asking me about, and this is what we're going to get to here. Yes, Cody's going to get BTF out here, chat, so we're going to show. Because I know a lot of you guys were wondering about this, so here is what happened to Cody. So the judge files a case, and hold on one second, chat. Sorry, chat. I had to talk to 2.0 real quick. All right. So what is this? This is an order from the court. And the court decides on the motions to dismiss. So Cody argues that counts 5 through 7 should be dismissed for failure to state a claim under 12b-6. And that defendant Dioscuri, remember Cody's alter ego here, should be dismissed for lack of personal jurisdiction. So the court is already responding, and it says that the 12b motions asserting any pleadings must be made before pleading if a responsive pleading is allowed. They say once an answer to a complaint is filed, any 12b motions to dismiss are rendered a nullity. And they say after answering the complaint, the defendants file a 12b motion to dismiss the plaintiff's claims. And they say under Rule 12b, these motions are a nullity. By filing an answer, Cody had eschewed the option of asserting by motion that the complaint failed to state a claim for relief. Okay. Now, they filed an answer and a counterclaim. Therefore, any motion to dismiss pursuant to Rule 12b is proper. Accordingly, it is ordered in a judge the defendant's motion to dismiss is denied as moot. Done and ordered. So, yeah, denied. Too late for Cody. Too late for Cody. They filed too late, chat, and that's critical. And if you go back to the timeline of everything that was filed here, they filed this and they should have filed that first. And normally what happens in federal court is if you file a motion under 12B and make a bunch of claims and then they get dismissed, then you could say, then we would like leave to file our complaint and our answer, and you're given that opportunity. Now, there are other issues too, though, that Cody has, even if the court were to say these were timely filed, Cody's got a bit of an issue. Remember, we talked about all those attorney's fees and all those attorney's fees? Well, for the state level claims, Cody's stuck because if you come over to the Florida state or the Florida codes here, it says act subjecting a person to jurisdiction in the courts of the state. Now, remember, this is for only the state level claims, not the Lanham Act claims. The Lanham Act claims are automatically in federal court. But to have subject jurisdiction over the personal jurisdiction over a defendant, we get down to the bottom here. And so Cody kind of screwed himself multiple ways here, chat. And this is very unique to Florida. And Matt had to point this out to me because this isn't the case in a lot of states. If a defendant in their pleadings demands affirmative relief unrelated to the transaction forming the basis of the plaintiff's claim, the defendant shall, after in that action, be subject to jurisdiction of the court for any cause of action. So there you go. That's they say regardless of the plaintiff. What the heck? Hold on. What the heck just happened here? That was weird. Jeez, I had stuff open in another tab and it started playing all of a sudden out of nowhere. That was weird. That was weird. It wasn't funny and weird, chat. It was just weird. And not in the good way. So this is an issue here. And they are in the and they say regardless of basis which the plaintiff made by amendment assert against the defendant. So there you go. You do not get to do by in your pleadings demanding an affirmative relief on a cause of action puts you in the court. So even for the state law claims, they would survive. My PC is glowing, yes. That was weird. It happens every once in a while if you've had stuff passed. So, well, you need it to be unrelated to the transaction, though. Yes, but the problem is the response has set them up this way anyway. So, Jeremiah Maddox says the SOV citizens are right. Did you hear, Sean? Subject matter jurisdiction over personal jurisdiction, the magic words. Well, that's not what? Anyway. So that is where we are. So yes, even under state law, they are. Yes, so that is where Cody is. Cody is not having a good day. This is not going to be helpful to him. So all of his motions to attempt to dismiss under Rule 12 are gone. They can't ever be used. And yeah, Cody's learning the word denied. So now he's left to fight his claims. He's not going to be able to get rid of them. And he's kind of stuck. He's kind of stuck, which sucks for him. Really sucks. But oh well. Couldn't happen to a nicer guy. Lois says, what is his lawyer's first name? Oh, it's David Gingras. It's the Laura Owens attorney. He's 100% the Laura Owens attorney. Yes, Matt says Draco. Yes, hi, Matt. Hi, Matt. Draco. Ghost of Peace. Why are you so obese? I don't know. Your mom cooks really well. What can I say? And from there, chat, that's kind of it. I know, like, some of you guys were like, oh, I need a Matt update. Well, there's your Matt update. Sorry, there's not a whole lot to it. I wish I could tell you there was more, but this is it. That's it for Matt. It's a very short one. but I know you guys wanted it, so oh, and oh, hold on, let me answer that. And then amateur iconoclast saying keeping Ohio's pets safe from the Haitians. Is that what Clyde's doing? Yes. Clyde's out there being busy. Nothing about being put in Wiggerville. No, that's not an issue there. Start again. I forget my license plates. I don't know what to tell you. Sorry. License plates are down. We need to save them for certain times. Stivels. Yeah, Clyde is actually out. I think 2.0 is making dinner or doing something out there in the kitchen. So Clyde's not going to come over here. He's stuck. And Johnny says, "Oh boy, this will be fun." Well, actually, there's not a whole lot of fun because it's kind of already over. We're kind of at the end. We're done. Cody completely kind of whiffed and did the wrong thing here. So Cody and his attorneys are now barred from trying to get the case dismissed on those claims. And yeah. So Cody's going to be in for the long haul here. Jefferson Post says, the libertarians do so much work to set back libertarians. The Venn diagram with maps is the worst part. That is a very, very true statement. A very true statement. Then Christine Fortunato has been a member for 5 months. Christine, thank you for being here. Thank you for the support. And remember, Christine, normally when it's like your time to be here, like when you get those things, you usually get like a free comment. So don't, you have something you want to say in there too. Don't pass that up because that's like a free super chat, basically. So that says read the whole thing again. No. I need a GlowCAD license plate. I'll talk to the person who got these to see if they could set me up with one. That would be funny. That would be funny. Glowing. You can't be a how did that name get through? How did this name get through YouTube? I'm surprised. You can't be a libertarian unless you like losing at every turn and being unlikable. Well, there we go. Cody is doing that. He is living up to the ideals. He is living up to the ideals. Oh. No, you're fine with the name. I just think it's hilarious YouTube let that in. Normally, they're pretty tough on that. Tony says Lamau. Oh. A lime green joint, says Lamau. There we go. So, yeah, that's really it, chat. I mean, Cody tried to file some motions to, and not going to lie, reading through most of it, I read it through earlier. It's not impressive. It was all kind of blah. And then the judge said, yeah, too bad, so sad. And I'm kind of surprised they messed that up because that part there, chat, is a normal part of civil procedure. You have to assert your motions to dismiss under Rule 12 before you ever do anything else. That's not specific to the 11th Circuit. You know how Matt was on, he talked about in Florida, you can't do a shotgun pleading where you just a million different things like that and just throw all your crap on the wall. So that one I'd understand they might not get. But the idea of, I mean, it's like that in every state. You have to file your motions to dismiss before you file a counterclaim or an answer. If you don't, you waive them. You only get to do those right at the beginning. You can't go back and try to like re-dip into the well. No, you get one shot, and then after that, it's kind of like a side-scrolling game. After you go past a certain point, you can't turn around and go back. Johnny says, "Be right back. Changing my name." Yes, Cody is a Feditarian. Yeah, I mean, it really seems to be that way. Logical bystanders, I think not having any spaces in the name is what allows it. Yes. Anus Repairman says, my name has been allowed on YouTube for over a decade. That's actually not that controversial. You might be a doctor. Like, there might be a doctor who deals with, like, repairing people who have prolapsed colons and be like, the anus repairman, or if you fix hemorrhoids, you are the anus repairman. Oh, see an Arsenal. Oh, hi, Othais, saying, everyone who steals my image tells me if you put it on the internet, it's free. Oh. And Tyler, Libertarian Podcaster, he's saying, how you doing? How you doing, Tyler? He's saying, thanks. Luke says the federal rules the same in every state. Well, every state adopt basically the federal rules, Luke. And I apologize if I misspoke in a way that didn't make sense there. Ohio has basically adopted the federal rules of civil procedure. It has basically adopted the federal rules of evidence. Now, there's unique little kinks in every state to the federal rules of evidence, but generally with their rules of civil procedure, you can basically go from state to state and have the same thing everywhere you go. So, for example, if you talk about a Rule 12b6 motion, almost every attorney in America knows what you're talking about. Winter Soldier says it stopped me. Say, is it a proctologist? Well, I don't know if proctologists actually do all the work. There might be like, I don't know. Do I look like a proctologist? Jefferson Post says you can't sue me in the court I'm using. Yeah, we got some big names in here tonight. We got some very big names. And he says, I have no idea how the name went through. I just saw the image. That's what came to mind. Hey, I agree. It's good. It's good. Is there other further information on the sheriff who shot the judge? Yeah, there is. And we're going to talk about that this week. There's a lot of remember I told you guys, there's a lot of weird stuff going on down at that place down in southeastern Kentucky. There's a lot of weird stuff going on. Now it's like there's a lot of weird stuff. Let me just say it like that. There's still stuff coming out. David Gingers blocked me on Twitter because I asked him about Section 230. Hi, Ivan. I'm sure he did. He's not a nice guy. I have to keep it going past an hour so I can see the gamer word. No, I don't need to. I don't need to. He says, why pay for a proctologist when you got a homie with a steady hand and some super glue? That's right. That's all you need is just a homie with a steady hand and a gentle push. Cosmo Kramer, the ass man. Yes. April London. Someone say big names. Yes. Hi, Ape. So is this the only trash case? It's only this trash case tonight? Yes. Yes. Only this trash case. Oh. Luke says it's only Kentucky. Yes, down in Whitesville, Kentucky. Yes, it is. That tells Ivan, give me a kiss. Oh. John says, your tits look lovely tonight, Sean. Well, thank you, Jonathan. Did you see Alyssa Mercati started deleting social media posts? Of course she did, because she's a retard, and that's not going to look good in her lawsuit. So that's totally what you do as soon as you file a lawsuit. You start deleting things. So April says, my escape's not going well. Oh, no. Oh, no. Hang in there, April. Oh. All right, guys. So, yeah, we are all set for tonight. That's it. I mean, Zona. Hi, Zona, saying, Gingas blocked me for asking very simple questions about why he decided blogging his client's active cases is a good idea. Well, yeah, that is true. Especially when he hangs out with Laura Owens. Like, it's not only just him doing it; he does YouTube videos and streams with one of his clients, and they're on there, and it's the weirdest thing I've ever seen. I cannot imagine. I can't imagine how it's a good idea. And I mean, this is one of those ones where if you wrote a letter to the state bar, or the ethics people saying, hey, would this violate the ethics rules? I'm sure they'd say yes in a lot of ways. Oh, you have homie kisses and it's totally not gay. Vodka's saying, so deleting things doesn't actually delete things, but does that not come off as odd or fishy to a court? Yes. At times, depending on what you've deleted, that can lead to negative inferences being made against you at trial, where they're allowed to say, look, she deleted things, therefore there's a reason to believe that that would have been detrimental to her case and likely would have supported JT's claims. Yes, that is entirely something that can be done. It's entirely something you can be done. Have I talked about Senator DeMora and his cracket law? I don't know what that is, so no. Send me something about that because I have no idea. Yes, the spinning. Oh, Adcast. Jeez, everybody's here. Nice. This is interesting. Well, we're done, guys. I was just talking about like how quick it is to get through Cody's whole thing here. So, and then you guys missed me explaining to somebody what FUDs are. I had to explain to them what a FUD is. So, you guys are just. Oh, I did hear about this. Yes, I need to do a video on it. Yes, because they don't want people flipping his. Okay, so here's an issue. I don't know how shitty your state is, chat, but in many states still, if you own a liquor store, the liquor doesn't get shipped to you from a Well, it gets shipped from a distributor, but the way it works is the state of Ohio buys alcohol and then gives it out. It comes from a state warehouse. And you might say, well, that sounds really retarded. And it is. There are many states with liquor control still, and they would probably try to tell you it's a safety feature, but no, it's a way for the government to be in charge of things and make money. So here in Ohio, when a liquor store gets liquor, they only get a certain amount. Like they get certain brands and they get certain things. And when you run a liquor store, the state of Ohio will tell you, hey, look, here's what's in stock. And sometimes it's rare stuff. And then you're like, oh, I'll buy some of that and sell it. Well, the law is they don't want people buying like a bottle of Pappy Van Winkle or something really rare and then turning around flipping it on the market, which why not? Why can't you do that? State warehouse like the ATF? Yeah, pretty much. So anyway, from there, the way it works, and I'm going to do a thing about this, is I could take that bottle and I could turn around and sell it online, or I could sell it somewhere, or I could turn around and, kind of like with ammunition. When there was right after Sandy Hook for a long time, actually, people like gun stores were big on this, especially like little shops. They would go to like Walmart and they would buy up all the fucking ammo and then turn around and flip it for expensive, like for ridiculous prices. Well, his argument is that you would go to, you would buy your, let's say this was a closed can of, seltzer, and you would come in and and as soon as you buy it, they come in and crack the top. So no longer nobody's going to buy an open bottle of whiskey. Once you break the seal on, you break it open because who knows what's in it? Who knows what you did with it? Nobody would ever do that. I mean, if you're a degenerate alcoholic, maybe. But that's an idea to prevent a secondary market. That just seems like bullshit to me. It seems like a bad idea. So we'll take a look at that later. We'll take a look for that later. Yes, only the state can engage in arbitrage, Tyler. Yes. How dare you make money that way? This is why us in Illinois call our retarded cousins. Yeah. But that's the issue here. Why is the state even involved in this? And it goes back many, many years. So it's something they do all the time. Pitchlock says the cheaper than dirt scumbags. Yeah, but it was like your local gun store would send in a bunch of fucking neckbeards at like 9 a.m. and go buy up all the ammo and then turn around and it'd be on the shelves. That was common, or people would go do that shit at gun shows. It was very annoying. Yes, the great 22 LR drought. It was bad. Job well done says it's not a White Claw. You're right. This wasn't a White Claw, but I thought I'd give it a chance. Because people had said Topo Chico was pretty good. these brands of seltzers like the tropical mango and stuff, like, yeah, not really my thing. Not really my thing. So let's see. SB Seller says it's an open container while driving. Well, not here. That wouldn't be an open container. Especially if that starts happening, then you've got a great defense of, well, it was opened by someone else, so I think you'd be fine. And yes, many states do have ABC stores, but here in Ohio they're not like ABC stores. But yes, like in many states, the state agency runs the store itself. So it's an entire racket. It's an entire racket. Yeah, there are no independent liquor stores in some states. I think it's that way in Virginia too. Ivan says they should make a Glock switch for Walter's PPK. From what, all 6 shots of 32 ACP? Is that really what you want, Ivan? What is going on out there? Oh, and Lois says in Texas it has to be in the trunk or at arm's length of the vehicle. Okay. Utah liquor stores are state owned. 10 Oct is saying, can someone explain open container thing to you? Okay. So the way open containers work are, well, here. So if you're driving along and you have, like an open beer in your car, and this is an alcoholic seltzer. So if, let's say it's like half full and I'm driving down the road and I get stopped by the police for speeding and it's sitting in there, well, you're not allowed to have open containers of alcohol in a vehicle. And the idea is, I can't say, well, the idea is it's illegal, period. Because otherwise you could say, well, I haven't drank this now because look, there's no condensation on it. It's not cold. Nobody would drink this warm. Well, it doesn't matter. They just say it's illegal to have open containers of alcohol in your car. Now, let's say this is a completely empty can rolling around on the floorboard and it's been collecting dust and it looks like it's been stepped on. Is that an open container anymore? No. But the idea is that they can't, they want to use that because they can prove you haven't drank, whether or not you've drank recently. It's another way for the state to justify doing an OVI on you and searching cars and detaining people for driving under the influence. But they can argue, oh, well, look, there was a beer can on the floor. And I've asked, and I've had these cases before where you ask the officer, I'm like, well, did you inspect the beer can? Was it cold? Was there condensation on it? Because even after if you drink your beer or whatever it is quickly, there's still going to be condensation on the bottle. Was it cold to the touch still? Was there any alcohol left in it at all? And when they tell you no, and you're like, well, so you have no idea when that can got in the car. And sometimes they've been dumb enough to say, like, well, I did look in it and there was a bunch of lint or dust and dirt. And then I finally had one where we watched on body cam after they arrested the guy. When you watch the body cam, the beer can had been like stepped on and crushed. And they claimed that was an open container. And guess what? That got thrown out pretty quickly. So it does happen. It does happen. You guys. Matt says, what if I just happen to be transporting my piss jug and get pulled over? Does a police officer have to taste all of my piss containers? Yes, under an obscure Florida law, yes, they do have to taste test all of your piss containers. They call Piss Jug Man over to do it. Oh. Zona says, I don't know what's going on, but I just want to say Matt is my beloved captain, and I his top lieutenant. You can regard anything he does to upset you as coming directly from me. And then Ivan says, it can't be an open container if you drink everything as fast as you can. Then the first container is empty and you are the container that is full. I'll try that next time I get a case like that in court. We'll try that next time. Oh. Dust Boot says, if I chug on my beer and step on the driver's seat, I'm clear. No, you need a lot more facts than that. But it was clear that it had been in the car and it had been scuffed up and that it had, been rolling around down there for a while. Oh my gosh, you guys are ridiculous. Do I know what Piss Jugs Man expert testimony fee is? No, I do not. Eman Resu says, shout out to my boy Chloe Nickerspick. Yes, thank you. Jefferson Post says the Ron Coleman streams, but professionally, yes. Nick Kreuzer says, all night chat. And Othaius says, tell Matt I'm slightly more proud of him than I am ashamed. That's an honor. That's an honor. We've all got our moments in the sun. Indy Deborah Raptor says, here in Louisiana, we have drive-through daiquiri shops that make open container laws silly. If the tape is covering the straw hole, all is good. That's interesting because you could just take the straw out of it and probably drink it. So, Agcast. Hi, Ag. If I flower my nose during a fun live stream, but the cops raid my house, say it's cocaine, could I get out of a Minnesota child endangering charge? I don't know. There are learned sages up in Minnesota who seem to think so. Oh my gosh. Who drinks from a straw as an adult? That's pretty gay. You're waiting for the day Alyssa posts the montage of me dropping N-bombs? Okay. Underbrass says, you poke the straw through the tape like a grown-up juice box. Oh, I thought he was saying like they put the straw in and they just slap tape over the straw. And I'm like, that seems really stupid, but okay, like, why not? That wouldn't be the dumbest thing I've ever heard. When do we get to the part where he starts jerking on camera? Oh no, chat. Oh no, chat. All right. Well, that is it here, guys. We're all done. We're going to land the plane. 373 people are on YouTube. Awesome. But then 381 people on Twitter. Like, Elon, you got to fix this because I know it's fake. People are not just watching. This is not that good. Yes, Othaius. Fly, yes. Land, no. Yes. I just need to know how to fly the plane, chat. I just need to know how to start the streams, not finish them. That's not suspicious at all. I was like you bite your lip at reading that. Like this. There. Bite it hard. Or he bit his finger, yeah. I forget how he's doing it. Yes. Winter Souls, I got suspended from Twitter again today. That sucks. That's no good. Just do what anime does and say, actually, the frog was God and pull the plug and sell model kits. Yeah, go out like Sky King. Yeah. Are there any Nick court dates this week? Yeah, he's got his Tuesday. He's got a hearing, or he's got a hearing. It's a settlement conference. So I don't know if he's gonna. I don't know what's gonna happen with it. I don't know what's gonna happen there. So, all right, chat. I will see you guys. We'll be on tomorrow. If anything big happens, we'll be there dealing with it. It's Monday already coming up. Fuck. Somebody's gonna have a case of the Mondays, and it's gonna be me. And then tonight, I'm gonna be on with Whiskey 77. He's a guy. He's been here on the channel. One of the a viewer. He's got a little show he does at 9 p.m. called Assholes React. So I will be joining him over there. We'll be hanging out. No Clyde. Yeah, Clyde's bunkered down. Clyde's bunkered down with 2.0, so he's enjoying himself. It's a cold, rainy day here. I'm sure he's just trying to stay warm. So, anyway, chat. Good night, guys. And just remember till next time, Cody, you're fucked, and you're not getting out of this. Just because you did it doesn't mean you're going to get away with it. Benjamin. Oh, it's Monday there. Oh no. Oh no. I should roll around like one of those hot dog machines at 7-Eleven. Okay, well. Any word on making your own switchies? Don't do it, chat. Don't do it. Please don't make your own switchies. I don't recommend that. Do that at your own risk. Do that at your own risk. Do it at your own risk, chat. So good night, guys. Take care. Oh.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?